Thank you everybody for coming out tonight and spending time with us for our very exciting speaker that we have this evening. For those of you who aren't familiar with our organization as of yet, we call ourselves William and Larry, Students for Equal Protection under Virginia law. We are a university-registered public policy group that is fighting to overturn Virginia statutes that discriminate based on sexual orientation. I also like to emphasize that we are 100% bipartisan, rights-oriented organization. In addition to our lecture series, we are drafting an amendment to the Rights, Privileges, and Immunities section of William & Mary's Code of Conduct. Although protections exist in the student handbook, we believe the time has come to add explicit language protecting members of this community from discrimination based on sexual orientation and sexual identity, alongside the other items such as race, gender, and religion. In the spring, we plan to lobby the Virginia Assembly on a host of LGBT rights issues, and we are teaming up with Virginia 21 to propose legislation to extend same-sex partner health benefits at Virginia public institutions. We are currently promoting our awareness campaign with our official t-shirt. The image on the front reads, William and Larry equals William and Mary equals Wilma and Mary. Ryan, could you stand up so everybody gets a look?
No, I was going to be down.
Okay. And tonight we have the privilege to welcome Claire Gastañaga. Did I say that correctly?
It's a G.
Gastañaga.
Gastañaga.
Okay. Brian, all the practice.
That's good. You know, it's so much better than I'm not even going to try.
I
have the G here too, which is the word.
It's the Nye that throws people off.
So her biography is extensive and extremely impressive, and I hope I can do it some justice, but it's very, very long and very important.
You can summarize.
So currently, Ms. Gastañaga is the executive director of the ACLU in Virginia. But for decades, she's been involved with legal and government relations at federal, state, and local levels. Among the many prestigious public service positions that she's held, she was the first woman to serve as Virginia's Chief Deputy Attorney General. She's also served as the Chief of Staff and Counsel to the Speaker of the Virginia House, Legislative Counsel to the Democratic Leader, Legislative Counsel to the House Democratic Caucus, Counsel to the House Courts of Justice Committee, and the House Committee on Finance, among her many other roles. While in the Attorney General's office, she argued cases in the Supreme Court of Virginia and at the Supreme Court of the United States, along with John Roberts, the current Chief Justice of the Supreme Court. It's pretty cool.
Yeah, I'd totally forgotten about that too. I'll tell you that story.
She has also led a nationwide recall of Ford E350 ambulances, I'm sure I didn't say that right, and led a team that shut down a rayon manufacturing plant that was polluting ground, air, and water in Northwest Virginia. Ms. Gastañaga has won various awards, including being honored as a fellow by the National Association of College and University Attorneys. She was named an Outstanding Woman in Law by the YWCA. In 2003, the SBA chose Ms. Gastañaga as the Virginia Women in Business Advocate of the Year. In 2010, Virginia's Lawyers Weekly recognized Ms. Gastañaga as one of 50 Virginia Women of Influence. And in 2013, Ms. Gastañaga received the Bernard D. Mays Award from the Serpentine Society at the University of Virginia for her positive contributions to the LGBT community, both within the university and beyond. So we're extremely, extremely honored to welcome you tonight.
Thank you.
Thanks for saying.
Okay, so the Deputy Director of Virginia 21, James Morton, is on our board of directors at the ACLU. Yeah, of Virginia. So I'm so glad you're going to be working with them on those issues.
And Gala, the gay and lesbian alumni group here.
Yeah?
He's on that as well.
Yeah, I'm sure he is. He's a grad. But we have lots of William and Mary connections. So James is the Deputy Director of Virginia 21. He just got that job. He just moved into that job like 6 months ago, I think. And he's really excited about working with students from across the Commonwealth, and we're excited to have him out there doing that because I view him as my secret weapon because we're trying very hard to engage and activate people who don't look like me but look like you, and some the ones in the front row. Although we want you to. But yeah, no, I mean, if you look at our demographics of the ACLU nationally, We are 2 white, 2 male, 2 old. And in the Commonwealth of Virginia, we do a little bit better, but we definitely need to expand our base across the Commonwealth and across all the different populations of the Commonwealth and across all the age cohorts of the Commonwealth. So I was pointing out to some of you before others came in, that you can be a member of the ACLU as a student for $5, and that's what these little envelopes are for. So if you'd like to be a member, we'd love to have you. One of the things that most people don't understand or aren't aware of is that the ACLU has been doing LGBT rights work since 1936, which was before your parents were born, much less before you were born. Our first case was a case defending Lillian Hellman. It was a playwright who wrote a play called The Children's Hour, which was censored because it had lesbian content. And the ACLU was there with Lillian Hellman defending her against censorship at that time. We also brought the very first freedom to marry case in the United States, not so successfully, unfortunately, the Baker case back in the 70s. Well before Lambda was even founded, we were doing freedom to marry, and we worked very hard on Romer v. Evans, which is the Colorado case that established that it is wrong for the government to take action directly intended to harm LGBT people. In 1977, we brought the first lawsuit that triggered the first state policy authorizing joint adoption by gay couples. And in 2010, we brought the case that ended the last law explicitly banning adoption by LGBT people. I'm really proud of this. The ACLU was the plaintiff's counsel for Diane Scheuer, who was a transgender woman who was hired by the Library of Congress as a man. And she was in the midst of transition, and she said, really, I'm ready to be Diane. And so Monday, when I report to work, because it's a new job with new people, I'm going to report to work as Diane Scheuer. And they said, oh, no, you won't, because we didn't hire her. And we represented her and sued under Title VII of the Civil Rights Act, and said she'd been discriminated against based on sex, that she was just garden variety sex discrimination. They were okay hiring a guy for this job, but they weren't going to hire a woman for the job. And we won, and it established the principle that Title VII sex discrimination could be used to protect transgender people from discrimination. And we now are extending that by arguing that it also can be used to protect people whose gender identity is not in accordance with accepted gender norms. We won the first court order allowing an openly gay service member to serve under Don't Ask, Don't Tell. That was Major Margaret Witt's case. We defended Constance McMillan, who was a lesbian student in Mississippi who became the global face for equality when her high school canceled the prom instead of letting her bring the person that she wanted to bring. And finally, we won the Edie Windsor case, the Velma case. And that obviously was the accelerant that moved what's been happening with LGBT rights from a sort of a slow march toward justice to suddenly, much more like a run. If you read the decisions in the DOMA case, there's architecture for future action to extend some of the philosophical and conceptual framework that the judges applied in that case beyond its facts. So what was the DOMA case about? The Edie Windsor case was about the federal law that said that the federal law is going to not respect state laws. So to the extent that state laws individual states decided that they wanted to accord people the full freedom to marry, the federal DOMA law said, well, that's fine, but we're not gonna recognize those marriages. At the federal level, we're going to protect the traditional definition of marriage by refusing to give full faith and credit or give full recognition to marriages between same-sex couples in those states that choose to do that. And what the court did was look at that and say, wait a minute, the federal government is not in the marriage business, right? The marriage business has traditionally been a state action. States have defined who can get married what the terms of marriage are, what the fundamental contract is for marriage since the beginning of our republic. And all of a sudden, we have the federal government stepping in and saying that, well, we're going to have a federal definition of marriage we're going to make all the states apply to. And why do we have that? And what the court said was, well, the only reason we appear to have that is that we want to discriminate against LGBT people. And the court said, in that circumstance, there isn't a rational basis for that discrimination. That the federal government can't treat two sets of people that are fundamentally the same, i.e., married couples with marriages legally recognized in the state of their celebration. The federal government can't treat those two classes of people differently unless they have a reason. And not only do they not have a compelling reason, they don't have any reason at all that suffices. And the court essentially held that differentiation in that case was all about the federal government wanting to say that LGBT people could not have the same rights as other people, and that was unconstitutional. So taking that concept of the Constitution, Scalia and other justices predicted that you can take that conceptual framework and you can apply it to new facts and come to different decisions about the freedom to marry even within the states. So on August 1st, which is about a month and a half after the decision came down, the ACLU of Virginia brought a lawsuit in the Western District of Virginia in Harrisonburg on behalf of two couples. One couple that wants to get married and can't, and one couple that is married but their marriage isn't recognized. And we brought a lawsuit that basically takes the conceptual framework laid out in the federal DOMA case and applies it to our state constitution, and says that our Virginia Constitution that says that marriage shall be between a man and a woman, and that the local and state governments and public entities in Virginia are not allowed to recognize any marriage other than that which is between a man and a woman, no matter whether it's legally celebrated in another state or not. That we brought that case to challenge the constitutional amendment and the underlying statutes under the federal Constitution. So we're saying that our marriage bans deny people the equal protection of the laws, that we're all entitled to be treated equally, and that our marriage bans deny that equal treatment, that marriage bans in Virginia and elsewhere should be subjected to what's called heightened scrutiny. And how many people are in law school or lawyers in this room? Okay, so let me explain this a little bit. So when you have sort of three levels that of scrutiny that the courts apply in judging cases where you bring a case and say something's unconstitutional. You have the rational basis test. You have heightened scrutiny. And you have compelling governmental interest. And what that's about is kind of what burden do you have to, what's your burden if you want to set aside something as unconstitutional? So if you're talking about a racial category or a fundamental right, then normally you need a compelling governmental interest to overcome whatever it is you're doing. So if I want to take away your free speech is a fundamental right guaranteed by the First Amendment, I can only do it if I have a reasonable time, place, or manner rule, and I have to be really clear that those are generated and founded in a compelling governmental interest. Keep the peace, something that is meaningful. And racial classifications all have to have a compelling governmental interest. Now, gender is not there. If you have a gender classification, like VMI is single sex, and you go to the United States Supreme Court and say you want VMI to go co-ed, the analysis was what's called heightened review or heightened scrutiny, but not compelling interest. And so when the VMI case went to the United States Supreme Court, what they had to show was that they had a strong governmental interest in keeping VMI single gender, and they couldn't meet the standard, the heightened scrutiny standard in that case, and so the court said VMI had to go co-ed. Rational basis is other kinds of classifications. So if the Virginia General Assembly passed a law that treated William and Mary students differently from University of Virginia students, there'd be a classification. The question would be, are those two classes entitled to equal protection of the laws? And the answer would be, well, we'd only have to have a rational basis for treating them differently. So whatever that rational basis would be, the University of Virginia is a larger institution, means something that constitutes a rational reason. And some of the issues in our case are, should sexual orientation be judged here or here, or here? In other words, is it an immutable trait? Is it something that should be treated like race and subjected to a compelling interest? Most people think that argument won't ever be successful. But the big issue is whether it is like gender and should be subjected to some kind of heightened scrutiny. So part of our briefing in this case is about whether classifications that involve LGBT people should be judged on the rational basis test or on the heightened scrutiny test. We argue it doesn't matter. We win either way, because that's what good lawyers do. They say, we think you should adopt this and the heightened scrutiny, and we think you should apply this to this case. But even if you don't choose to agree with us about the standard of review, we win on the rational basis test too, because there's absolutely no rational basis for treating two legally married couples differently, or for saying that this couple can get married and this couple can't. The other thing that we've argued is that marriage, though, that marriage itself is a fundamental right, and so even if sexual orientation isn't entitled to be judged on the compelling interest standard, a denial of the freedom to marry should be judged as a fundamental right and treated so that you can't take it away or keep it from somebody unless the government has a compelling reason to do so. So we have this architecture where there are a couple of different arguments, but it all comes down to the same fundamental conceptual idea, which is that there's no difference between a same-sex couple that either is married and wants to be recognized, or a same-sex couple that wants to get married, and an opposite-sex couple that they should be treated the same, and that any disparity in treatment should be determined to be unconstitutional. And it's you can see why the brief is 65 pages long, because it becomes, you sort of argue and then re-argue and then turn around and argue it again, and you end up with 65 pages of briefing. We are bringing to bear in this case a lot of information about the history of marriage, about the political power or lack thereof of LGBT people in Virginia. One of the things that makes our case compelling from a kind of a national strategy perspective is that the Virginia Marriage Amendment is so much broader and so much more onerous than marriage amendments in other states. For example, 2 weeks ago, our tax department put out a bulletin about how legally married LGBT couples should be treated under Virginia tax law if they have been accorded the right under federal law to file jointly, like any married couple. What happens in Virginia when they come to Virginia? And our tax department has said, well, when they come to Virginia, in terms of their state taxes, they are not entitled. We normally have what's called a piggyback tax system, and the tax department saying, well, we're going to ignore that, and we're going to require that couples recalculate their adjusted gross income, back out of their adjusted gross income calculations any deductions they've taken at the federal level for authorized deductions for health insurance, make them file as separate and single individuals when they filed married filing jointly at the federal level, and essentially do a whole new, undertake the pain, the agony, and the expense have a whole new way of looking at their income for tax purposes. Moreover, our tax department went beyond that and said that Virginia businesses that have taken deductions for health insurance benefits and other things paid to people under the federal law also have to recalculate their taxes for state tax purposes. And our tax department went that far, they say, in contrast to Missouri, which also has a Republican governor, and said, just file. You know what? However you file to the federal level, file at the state level, just file. And our state tax department is saying, because we have the second paragraph in our marriage amendment that says not only is marriage defined as being between a man and a woman, but no public body in Virginia can recognize in any way a relationship that looks like marriage or feels like marriage, sounds like marriage, that you can't recognize any relationship other than traditional marriage, that because we have that second paragraph, they're compelled to do this incredibly complicated treatment of people's taxes. We don't think that's necessary, and I'm working on some actions to try to convince the incoming administration and the current one that they need to change what the tax department said. But it makes our getting our case to the judge and getting it resolved even more urgent, because there are people who have real dollars at stake in addition to their dignity and everything else. So if and when we win our case, that'll resolve these issues, because marriage will be marriage, and it won't matter who the couples are, and everybody will be treated the same. And we are hoping that happens sooner rather than later. There are two cases in Virginia. There's our case in the Western District that was put to the judge on cross motions for summary judgment on September 30th, and he has briefs, and at some point he'll make a decision or he'll have a hearing on those motions. A motion for summary judgment is a motion that you file as lawyers when you say the facts aren't really all that much in dispute, the law is in dispute, and so you can make this decision without a trial. If the judge grants our motion for summary judgment, we've essentially won, and the other side then can appeal our decision, or vice versa. The judge in the Norfolk case, which involves two couples now as well, also has motions for summary judgment pending before her that were filed on September 30th. And so one or both of these cases could be moving up to the appellate level sometime in the next 6 to 8 months. On our side, we have the National ACLU, the Virginia ACLU, Lambda Legal, and lawyers from Jenner and Block, a big law firm that are working pro bono. In the Norfolk case, there's a local firm headed up by a really good trial lawyer named Tom Shuttleworth, and that's the case that David Boies and Ted Olson have now weighed in on as co-lead counsel. And they're one's in the Eastern District of Virginia, one's in the Western District of Virginia, and they'll both end up in the Fourth Circuit Court of Appeals eventually. But they are very different cases, and we have different theories. And our case is filed as a class action, which means we're seeking to represent every couple in Virginia that is either wants to get married and can't, or has a marriage that they've entered into in another state and it isn't recognized. And if our class is certified, then everybody who's in those two classes will be equally affected by the outcome of the case. Ours is the first case in the country that was brought as a class action, and we did it because the Prop 8 case in California was brought in the Northern District of California, and when it went to the Supreme Court held that there was no standing to have appealed. There was a positive decision at the district court level, which is a good decision, that said marriage is a fundamental right and you can't discriminate against people based on their orientation. 134-page decision, lots of facts, really worth reading. And when that was appealed, it was appealed by people who were actively engaged in trying to pass Prop 8, because the governor of California and the attorney general in California refused to be party to the appeal. They just wanted to just implement the decision and move on. And when they got to they went to the appeals court, and they got an affirmance, and they went to the Supreme Court. Well, what the court did by saying there was no standing was void there was no decision at the Supreme Court level, and they voided the appeals court decision. So the only decision that still exists is in the Northern District of California for the plaintiffs that were in that case. And there are court clerks in California and some of the more conservative counties that are saying that decision doesn't apply to me and I'm not going to issue a license. I'm still covered by the California Constitution. And so we didn't want to take that risk. We want to have a class action that clearly decides this case for everybody in Virginia who's an LGBT couple that wants to get married or an LGBT couple that's married and wants to have their marriage recognized. One of our plaintiff couples lives in Winchester, and Christy Berghoff commutes every day to Washington to her job with the federal government. And in her first press appearance, she said, "You got to think about this." She says, "I get in my car and I drive to work, and I get to my desk, and on my desk is the picture of my wife and my little baby who's 8 months old, and I'm a married woman with kids and with a kid and benefits and all that stuff. And then I get in my car to drive home at night, and I cross the Potomac, and I'm a single mother. And my wife has no legal right to my child. I have guardianship agreements and all this stuff, but they could be challenged because that would be recognizing our relationship, and maybe a court would decide that they couldn't accord any benefit to that." So she says, "Think about that. I drive across a river, and I'm a single mother, but at my job, at my desk, I'm a married woman with a kid and benefits." So how much sense does that make? And you got to admit, it doesn't make a lot of sense. The other case, the other plaintiffs, Joanne Harris and Jessica Duff, live in Stanton. And Joanne found out relatively recently, and after she had their child, who's now 4, that she has epilepsy. And she says, "Every day when I go to work, I worry that this is the day I'm going to have a seizure, that I'm not conscious after 15 minutes or a half hour, that I'm incapacitated for a longer period of time. And, my partner doesn't have any rights to take care of our child." Again, they've gone through a lot of expense to try to build a legal architecture that protects their relationship. The bottom line is, anybody who wants to challenge Jesse's ability to take care of that child, can go to court and say, "You can't enforce this guardianship, because to enforce that guardianship would violate the Virginia Constitution, because it would require you to recognize the relationship between the child's parents in order to do it." So, they tell very compelling stories, and they're both sets of plaintiffs are astoundingly courageous, and their willingness to talk about deeply personal stuff that's about their real lives and what this really means to them. And so we're very happy to be their lawyers, and we're very hopeful that we will. I like to say to people, the Virginia affiliate of the ACLU was started by lawyers who litigated the Loving versus Virginia case, which was the case that established that laws banning interracial marriage were unconstitutional because marriage is a fundamental right and you can't deny it to people based on race. And we're hoping to celebrate our 50th anniversary in 2019 by being able to say that we not only were founded on Loving versus Virginia, but we're celebrating our 50th anniversary having brought freedom to marry to other Virginians who were similarly denied what we think is a fundamental right. That's all I wanted to say about that. I told these guys that I basically wanted, because we have a pretty small group here, I wanted to ask you all what I can tell you. What did you come here tonight to learn? What can I talk about that would satisfy some curiosity or some question that you had when you came here tonight? Yeah. You.
I'm definitely all for same-sex marriage all throughout the country, but I'm not exactly sure how to personally make other than, like saying I'm for it, I don't feel like there's much I can do except for like when it's on a ballot.
Okay.
What would I do?
We have a director of public policy, and this is his email. And we're working with Equality Virginia and others on an outreach campaign and an education campaign that is around our legal marriage work. We know that, well, here's the good news. When Loving versus Virginia was decided, the day the Supreme Court decided it, 75% of Americans still thought that interracial marriage was wrong. Okay, that the Supreme Court was leading the public. The good news is that in this situation, at this point in time, if when the Supreme Court decides this case and says that marriage is a fundamental right and can't be denied to people based on sexual orientation, the public is ahead of the court. And I really believe it'll be a sort of a non-event. But that doesn't mean that we shouldn't be building the court of public opinion framework around the judges that are looking at these cases. So Frank is in charge of doing that part of our work, and he's working with James Parrish at Equality Virginia and others on outreach, public education, letters to the editor, op-eds, personal stories, all these different approaches that allow people to see the reality of what this means and to see that that there'll be support for a decision that finally affirms freedom of marriage, regardless of sexual orientation. And so I would encourage you to send an email to Frank and tell him that you want to be involved in our marriage work. In your communities, I spoke recently at the before some undergraduates at the University of Virginia, and I did say to a number of the LGBT students who were there that the single most activist thing they could do was to be totally and completely and openly themselves. That the reality is that every bit of polling I've ever seen documents two things. That how people feel about LGBT rights is largely directed by their religious beliefs, and whether their particular religion teaches that sexual orientation is a behavior or is who you are. And it's part of the reason why more Catholics voted no on our marriage amendment than voted yes, because in Catholicism, sexual orientation is seen as being who you are. It's just sinful for you to be who you are, which is a little weird from my perspective. But in more Protestant evangelical religions, there's a strong belief that sexual orientation is a chosen behavior. So that's the number one thing that guides people's political beliefs. Now, the thing that can change that is not discourse or argumentation or trying to help people see that their faith is wrong. The number one thing that can change that is what?
Knowing gay people.
Knowing, loving, caring about, being related to someone who's LGBT. So that's the senator who says, I had a choice between my faith and my son, and I chose my son. And that's the reality. And I believe that's why public opinion has shifted, because as more and more of, I asked a group of about 30 high school students from a Lynchburg Catholic high school, 15, 16, 17-year-olds, how many of them knew someone their own age who had come out to them as LGBT, and 2/3 of the kids raised their hands. Now, when I was in high school, it turns out in retrospect that the guy that was my senior class president and my student body president was a gay guy, but yeah, I didn't know that till we were 50. The first person that I consciously know I knew was gay was a law professor when I was in law school. Now, that's not, my grandmother, my great aunt, a whole bunch of people moved down to Key West in the 40s, and they were always around people down there. And I always knew about gay people, but in terms of somebody I knew, I was in law school before I knew somebody who was LGBT. People don't have that experience anymore. And I think that's what's really changing and making public opinion move is that as more and more people have been out and real, then people are going, well, wait a minute. I sort of theoretically believe this, but it's Fred, And so these students were saying, well, how do we get active? How do we get, how do we become I don't have time to be an activist. You don't have to have time. You just have to be you. Just be you realistically and real every day. And that's a huge contribution to the movement. But we are doing some other things. So Frank is the one who can help you connect to what's going on, and we'd love to have you. And the stuff that you're talking about doing with this group, letters to the editor are really important. Meeting with editorial boards and talking with them about how young people see these issues or how your student group sees these issues. Working with Virginia 21 on the benefits issues. Now, I will tell you that you need to be working really hard to get the UVA students involved. Because you see, UVA is self-insured. And UVA can do whatever it wants to on benefits if it has the guts. William & Mary and the other schools are all in the state system, so we have to change the benefit structure for all state employees to change the benefit structure for William & Mary employees. Unless you can figure out a way to amend what I call the freedom contracts. The senior institutions have all gotten some ability to separate themselves from some of the state policies in return for giving up a lot of the state money, or having given up a lot of state money, they've argued that they should have more freedom, whatever. I don't know which one came first. But the other thing you might be able to do is get the university agreements shifted so that the universities can be free to make their own personnel decisions. They're not currently free to do that on healthcare, except for UVA, which is self-insured. So every time I'm a UVA law school grad, every time I go there, I make myself really unpopular with the administration because I make this speech every time I go there. No matter what the forum, I'll say, so if you talk to your president, tell her I said. Somebody needs to get a backbone here and just do it. But the benefits issue is complicated, and I'm happy to work with you on that. But it is something that, I mean, look, the University of Alabama has equal benefits for their faculty. How can none of the universities in Virginia have equal benefits? I mean, it's just ridiculous, it really is, and for staff. But it is a little bit more complicated architecturally. But all the things you're thinking about working on are really, and the non-discrimination, the bill that would say that no state employee can be fired or treated differently based on sexual orientation or gender identity that EB's been working on since 2006. The universities have not been as front and center in advocating for those bills as they could be. In the last go-round, the vice president at VCU came and testified. The president of Virginia was in the room. Your president was actively engaged behind the scenes, but in terms of public testimony, not so much. And that's because of concerns about budget. And the other bill that went through last session with nobody speaking against it except the ACLU was the bill that says that religious and political student organizations should be able to discriminate in their membership and leadership based on their religious or political views. And we tried really hard to stop. I threw myself on the tracks, but the train just ran over me. And the universities had made peace with it in the sense that they let it go, and there were no student groups or anybody up there testifying against it. And so it passed, and what it did was reverse a 5-4 Supreme Court decision. And the Supreme Court decision, which was about the Christian Legal Society at the University of San Francisco, said public universities have the First Amendment right to decide what their curriculum and their extracurriculum is, that they have academic freedom. And if they choose to have a policy for their extracurriculum, which is that if you are a recognized and funded student organization, you must be open to everybody. You can't choose not to let this student or that student into your group. The public universities were free to have that speech as a First Amendment protected, part of their voice for their academic freedom. And what the state law does is turn that on its head, and it says public universities in Virginia must allow student organizations that are religious or political to discriminate. And it's not a happy day when that passed, from my perspective. And, you all need to watch carefully to see how that plays out at William & Mary, and you just speak out against it. And you need to call me if you have somebody you feel has been discriminated against by one of those groups, because I'd really love to challenge it.
There's a story, one of my good friends, he was kicked out of his position in Catholic Campus Ministries for being openly gay. And I don't know, they just upheld that and said that that's allowed. So.
Well, that's what the law says, that they must allow them to do at this point. But, what the Supreme Court recognized was institutions have their own academic freedom, and it's like the state law compels the university to speak in a certain way. And that's not to say, look, Catholic ministries, if it wants to be discriminatory, it still has to have access to campus. It still has to be able to, interact with students. It still has to have equal access. The question is, does it have a right to be recognized and funded by the university so that it is effectively speaking with the university's voice? And what the Supreme Court said is no. It does. You can have an all-comers policy at the university as a part of your academic freedom. And what the state statute does is turn it on its head and say that state universities in Virginia must allow them to discriminate. But we're looking for an opportunity to challenge the state statute, so keep in mind. Yeah.
Do you think the Supreme Court of the United States is ready to impose same-sex marriage on unwilling states, or do you think they're trying to buy more time with the standing issue in the Perry case?
I think they were in a funny position, because here's what, the people who were at the arguments in March were surprised by the opinion and the breadth of the opinion. People in March, when people were at the oral argument, they really felt, my guys came out of there saying, okay, well, we're going to go really slow here because they're not ready, and we can't get up there again. We have to slow things down a little bit so we can give them 3 or 4 years, and we need to have X number more states do their thing before we go up again. And then the whole pace of everything just accelerated beyond anybody's imagination. So all of a sudden, people who were projecting that we'd be at 14 states in 2016, we're already at 16 states, and 38% of American population are already covered by freedom of marriage statutes or constitutional protections. So by the time a case gets up there now, even on our cycle, it's going to be a year or 2 years. By that time, Oregon will have voted, and I think everybody believes that Oregon's going to repeal their amendment. And New Mexico will be clarifying its position because it doesn't have. Pennsylvania, the issue in Pennsylvania is being brought up where there is no state constitutional amendment. So they're looking at it differently. So I think by the time you get up to the court, you're going to have a majority of Virginians already covered by freedom of marriage statutes. And so I think it will look very different to them when we get there than what did it in March when they were hearing the DOMA case. And it was very different in June when they issued the opinion than it was in March. And so I think this is a flywheel that's gotten some momentum, and I really don't think it's going to come to a crashing halt at the Supreme Court at this point. Yeah.
What's the status in Nevada of legalization?
There are now 44 cases across the United States on freedom of marriage, and there are the ACLU has a program called Out for Freedom, and we're working on the ballots where we can. So Oregon has initiative and referendum, and we're working with people to put the repeal on the ballot. We're working in legislatures where that's possible. So we were active in Maryland and New Jersey, and then we're working in the courts. We're working in state courts in Illinois and in federal courts in Virginia and North Carolina and Pennsylvania. The Nevada case is a Lambda case, and I'm not 100% sure exactly where it is right now, but it's going to go to the Ninth Circuit, and I think folks are a little concerned about the way that case is currently positioned, but I think what will ultimately happen at the Supreme Court is exactly what happened in Brown versus Board of Education, where there was a similar, number of, Brown versus Board of Education, we all use one case's title to call it. There are like 6 or 7 cases consolidated for a hearing at the Supreme Court in that case. So we suspect that you're going to get a number of different decisions, and then we're going to have some kind of consolidated hearing at the Supreme Court level. And it could be the Nevada case gets there before our case gets there, but it might not. Yeah.
I'd like to better understand why sexual identity wouldn't be be judged with high scrutiny? And why gender is still is at heightened? I don't understand the reason.
Because?
Because?
Because, I mean, and this'll, I'm gonna out myself here. I was the lead lawyer on the VMI case when it was first brought, and I was defending VMI's right to say all women. And at the time, I could do that because of where gender was. I could argue separate but equal was okay for gender, but would never be for race. And there, obviously, both of these are immutable characteristics. One can argue that the reason gender isn't up there is because there's no Equal Rights Amendment, because the Constitution used to only apply to guys. But it's one of those legal things that it just is because. So then the question is, do we really think sexual orientation and gender identity is going to be treated the same as race? I don't think it will be. I do think that we'll get a court to agree that it's entitled to heightened scrutiny. But I also believe with respect to freedom to marry, they don't have an argument for why there's read the briefs. I mean, it actually is hard for me to read the briefs in one sitting on their side because I have such a hard time taking them seriously. I mean, they're talking about marriage is about responsible procreation, and that's why they need to. The state has an interest in marriage because it has an interest in making sure children are born and responsibly. And I'm thinking, okay, and how does that translate into two people who love each other and want to be committed who happen to be the same sex? Why wouldn't they be responsible parents? And to my mind, my LGBT friends are much more responsible about their procreation than some of my straight friends, because they have to be much more intentional in some respects, in some cases. But they talk about responsible procreation. They don't have any decent. It's tradition. Well, shoot. I mean, interracial marriage bans were 300 years of tradition when they were set aside. So how long is how long is a tradition before it becomes one that's protectable and one that's set asideable, if you will? So they just don't. I mean, they reached back to try. They're so desperate for an argument. They cited the eugenics statutes. I mean, we used to have a statute on the books that said, women who are mentally feeble can't get married till they're 45. And to bolster their responsible procreation arguments, they cited that statute. And that dates back to the eugenics movement, for which the legislature has apologized. So, it's hard for me to take some of their arguments seriously. And I'm glad there are other lawyers on the case who are ready to, really sit down and argue with them about some of these things, because I have trouble not laughing about some of them.
So was it a Supreme Court decision that gave race its position?
Well,
And it will be the highest federal court that ends up deciding whether.
the whole architecture of the constitutional analysis is court made.
Okay.
Yeah.
And so what if okay.
Yeah, but if you look at our Constitution, there are specific protections built into our Constitution that have to do with race that are not present for gender or for LGBT.
So that's probably the biggest reason.
Right, and that's why when we make our compelling interest argument, we tie it to the fundamental right as opposed to the class of people.
Okay.
So we're saying, they don't have a compelling interest in denying this fundamental right, freedom to marry, to anybody who, otherwise is eligible. Gay cousins still can't get married. Okay? Still can't marry somebody under 15. So there you do still have to meet the same eligibility standards. You just can't differentiate based on the orientation of the two parties. Yeah.
I was also wondering, are you focusing solely on the equal protection doctrine, or are you also using substantive due process? Because I know Scalia talked about in his dissent in the DOMA case that substantive due process had fallen out of favor. So I was wondering you were going to use that argument at all.
We do use due process and substantive due process, but I think all of us think we're more likely to win on equal protection. But substantive due process is essentially the Romer case is really much more about that, and that's why you'll see we have affidavits and expert witnesses about the political power of LGBT people or lack thereof, and that all goes to our substantive due process. So we are using those arguments as well. We just don't think they're as strong, I think. But yeah, we're right here. The scope of fundamental right or liberty interest under the due process clause does not depend on who is exercising that right. So yeah, we have a whole section in the brief on due process. Yeah.
I know you hate to answer questions like this, but I'm going to ask anyway.
Oh, well,
What do you-
okay, that sets me up, I'm ready.
Well, because
Yeah.
the attorneys don't like to guess like
Yes.
this, but I mean, based on the judge that you're bringing your case before and his or her previous leanings, how do you think things will go at that level?
I don't inhabit judges' minds, and Judge Urbanski is a relatively new judge, so there's not a lot of record to look at. We think he's a very fair judge. We've been in front of him on other cases. Judge Urbanski was the judge in a case we brought against Pennsylvania on public prayer at their city council meetings, and we won that case, and we've now won an attorney's fee award, except now the Supreme Court's going to revisit that whole body of law, so I don't know what's going to happen to it. But we found him very fair. What we were looking for was we wanted to bring this case in the Western District of Virginia because we wanted to make a statement that this is not an issue that's about the Republic of Arlington or or urban centers in Virginia, and it's not a Golden Crescent issue, it's an every Virginia issue. And our folks from Stanton are both farmers' daughters, one from the Valley and one from Southside. Our folks in Northern Virginia are everyday commuters who, one of whom is a stay-at-home mom who is works out of the home, and the other one goes to Washington. So we wanted to tell a story that was about all of Virginia and who people are. And so we chose to be in the Western District, and we are glad that we were able to get Judge Urbanski because we think he's a very fair judge. And that's what you want is a judge who's going to decide on the law and not ideology or politics or any of those other things. And we think he is a very thoughtful, smart, fair judge, and that is the best kind of judge to have no matter what. So that's what that's why we're glad we have him. Yeah.
So if you win the case in the district court, who would defend the Constitution?
Good question.
And will they have standing if it's not the administration?
I don't know.
It's a very
one of the
political
things we don't know the answer to is that right now we have sued the governor, we have sued the registrar of vital statistics, and we have sued a clerk of court. And the clerk of court is a constitutional officer who stands in the shoes of all the other clerks of the courts and all the other 130 some odd localities. The registrar of vital statistics is not really a political appointee, but is somebody who could, serves at the pleasure of, so could be replaced, but is a statewide official, and would either of those people, if they don't like the outcome, would have standing to defend the decision against them, no question. The governor's asked to be dismissed on the grounds that the governor of Virginia doesn't have enough power or authority to affect this to be a defendant. And one of the fictions that you're stuck with here is we're not allowed to sue the state because the state's immune from suit in federal court. So you have this architecture where you sue people in their official capacities as sort of standing in. You'd really like to just write, Harris, Duff, and Berghoff and Kidd versus Commonwealth, but you can't do that because you can't sue the state. So you have to pick people that represent the Commonwealth's interests in their roles. And so we have a statewide official, we have an elected constitutional officer The governor's asked to be dismissed. We don't know if he'll be dismissed or he won't be dismissed. So we could well be in the position where the people defending the constitutionality are the clerk and the registrar of vital statistics. Now, depending on the outcome and the decision of the new attorney general, normally a constitutional officer would be defended by what we call risk management counsel. And so that's somebody who's being paid by the insurance company. There's a state risk management agency, which is essentially the state's self-insurance agency. And that agency is paying for private counsel for the clerk. So that's not going to be affected. The registrar of vital statistics normally would be represented by the AG's office. Now, the AG could say, I have a personal conflict and I'm not going to defend the Constitution, but I'm going to appoint somebody else to represent the registrar if she wants to move forward, or he, can't remember, he, she. And, or the AG can say, I'm going to deny a defense. But you'd still have the constitutional officer. So, you know, it's hard to know. I mean, what happened in the Prop 8 case was that after the district court decision, nobody at the state level wanted to defend the Constitution. And so it went up with people who had been part of the advocacy group that got Prop 8 on the ballot and passed, that said, our interest is at stake and we want to represent. And the court said, no, you don't have standing.
Do you think it's possible that a member of the Virginia Assembly could represent?
Well, I mean, they didn't, in the DOMA case, they didn't throw the Congress people out. They didn't say that the Congress people didn't have standing to defend the federal statute. So I don't know. The standing issues are very hard. And standing in state court in Virginia is very narrowly defined. You have to have an actual harm that you suffered, and or you can't get into court. Which is what has always frustrated me about the current attorney general, who goes to state agencies like the Juvenile Justice Agency, or the Social Service Agency, or the Board of Health, or the Tax Department most recently, and says, if you don't do what I say, I'm not going to defend you in a lawsuit. But the reality is there isn't anybody who would sue, except the people who are getting the benefit, who weren't getting the benefit, anyway. So it's, the whole standing issue is a really interesting question, but we think, I mean, obviously we don't want to be in a situation in which we can't get a decision because we don't have anybody who can defend the Constitution. And it would be nice if I thought winning by default at the district court level was somehow going to be enough. I'm just not sure it'll be enough for some people. So I want a decision. I want a real decision. I want a majority decision. Yeah.
So speaking of decisions, so if we're talking about these decisions being a year or two down the road, I mean, by October 15th, we have to decide whether to file Virginia taxes separately or...
So here's what I've told people.
So what's your best advice on that?
Yeah.
Kick up the
Okay,
fuss or
I'm
go along?
not a lawyer for this purpose. I mean, I'm legally trained. I have a license, but I'm not giving you legal advice.
I understand.
You do need to talk to a lawyer and an accountant, and I will tell you theoretically what I think are the possibilities. Our computers in Virginia are not programmed to figure out the gender of the taxpayer. When you file your taxes, there's nowhere on that form that you check any box about your gender, your sexual orientation, any demographic information at all. And they're not programmed to decide that Mary and Mary is not an okay couple, and Bill and Mary is an okay. I mean, so I could envision a circumstance in which I just went ahead and filed, and then if they disallowed it, I would go to the ACLU and say, will you defend me on the grounds that what they're doing is illegal? Or I would assume that by the time they got around to disallowing it, that there would have been a decision that would have made what they've done wrong to begin with. But I think, I mean, I have these strange conversations that I promise you I'm only having with my LGBT friends who call me up and say, should I get married? I'm like, I don't know, should you? and because they're really doing a really financial analysis, because there is a marriage penalty in the tax code, in case any of you don't know that. If you get married and you and your spouse have equal income, about equal incomes, you pay more if you are married filing jointly than if you file as single people. Okay? Two people making X number of dollars and they individually, their taxes add up to more if they're married filing jointly. So that's what they call the marriage penalty. And so, I mean, I have friends who are doing this analysis where they're putting the marriage penalty of the income tax up against the long-range benefit of I will qualify for Social Security, I will be able to assure that my spouse will have the benefit of the big exemptions from, estate taxes, all that stuff. And there's like this whole architecture that you have to kind of think through if it's a choice. Now, once you've made the decision to get married, I mean, the other thing that's happened to some of my friends is they got married, when California first allowed marriage before Prop 8, and they really sort of did it because for the reason most of us get married, which was really romantic, and now they're like going, oh, wait a minute, I'm going to have to pay more in taxes at the federal level? I'm going, well, yeah, because now you're married for federal purposes, and that's your legal obligation to file as married. Married filing separately or married filing jointly. So I encourage people to go to their lawyer and their tax professional and decide what's better for them, and then just understand that the tax department people, before the AG's office got a hold of them, were telling people to file, just like they had filed at the federal level. And then all of a sudden the AG's office got a hold of them and shook them around like a rag doll and told them that they had to do X, and that's when this bulletin came out that said the
My
contrary.
inclination would be just to file jointly, the way we would
And
with
I'm
federal.
certainly not giving you any advice, but I would certainly ask somebody what would happen to you if you did that.
Right,
Yeah, and particularly if it's financially better, then I think But then on the other hand, if it's not, then you file separately, and if somebody comes after you later, you go, I didn't think you recognized my relationship, So it seems to me you make the best choice for yourselves, and it might be one of those nice times when the law will work out in your favor regardless. So I think
And the
it's,
incoming AG